This is News 24. I'm Erin Bates. One story that's dominated news since last week is the information that South Africa has given notice it's planning to withdraw from states or nations that are listed as signatories in the Rome Statute, and that we're basically leaving the ICC, the International Criminal Court. Now, with me today is Lawson Naidu from the Council for the Advancement of the South African Constitution. And Lawson, you're going to help us understand the kind of legalities of this decision and what case there may be for contending it.
Indeed, and I'm pleased to announce, Erin, that this morning CASAC has lodged an application in the Constitutional Court to challenge this decision by government to put forward the instrument of withdrawal to the United Nations last week. We believe that there is no basis in law for government to have done that. It's a fundamental breach of the separation of powers, in that the Constitution clearly gives a responsibility to Parliament to take decisions regarding the binding effect of international treaties, and therefore it is Parliament that needs to be charged with any decision to extricate ourselves from those responsibilities, and the executive have no role to play in initiating that process.
That's astounding news. I mean, this is a breaking story then, that you as an institution of civil society have decided to contest what the Minister of International Relations and Cooperation has written and signed off.
Yeah, because it is our firm belief that there is absolutely no basis in law for the Minister to have taken that decision, or indeed for the President to have taken that decision. This is a matter that resides with Parliament, who ratified the Rome Statute and also passed a piece of legislation domesticating our responsibilities in relation to the international treaty into our domestic law. So for the executive to take action without Parliament even having discussed the matter is highly irregular.
So that's something that the Minister of Justice dealt with when he had his briefing on Friday, and Michael Masuta, the minister, said that he would be referring elements of the decision to Parliament. It sounds like what you're saying is that the whole decision, the wholesale decision, needs to be debated, and I suppose then in the Constitutional Court.
Indeed. In fact, what the Minister has done is, in fact, to put the proverbial cart before the horse. This is a matter that should have started in Parliament. Parliament should have taken a decision as to whether it wants to review South Africa's membership of the International Criminal Court and its status within the Rome Statute before any action is taken by the executive. The fact that Parliament has not done so means that this decision by government can have no legal effect whatsoever, and we are calling on the court to compel the government to withdraw its intention to withdraw.
So who are the respondents then in your case?
Well, it's the President, it's the Minister of Justice, it's the Minister for International Cooperation, it's the presiding officers of Parliament, the National Prosecuting Authority. Those are the primary respondents in our matter.